Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, if you can believe it or not, we're in session number 10. Session number 10 of our ongoing series regarding the new medical legal fee schedule. And it's been some time since we had our last discussion on the new medical legal fee schedule. And the reason for that is I wanted to allow some time for us to live in and experience day-to-day practical application of the new medical legal fee schedule before I brought to you this final discussion in this particular series. And the new medical legal fee schedule has now been in effect for 4 full months. The new medical legal fee schedule was implemented on April 1st, 2021, and this is being recorded in the first week of August 2021, so that's April, May, June, and July, 4 full months that we've had to experience life as a qualified medical evaluator in the new medical legal fee schedule. And what I want to share with you in today's discussion are what are some of the new, recent, and most recent applications that we're seeing the parties employ in using the new medical legal fee schedule to exercise their incentive and to gain an advantage and to gain some cost savings in the overall cost of medical legal evaluations. So I have some fascinating ideas to share with you today as to how you as a qualified medical evaluator can thrive and survive under the new medical legal fee schedule, because I'm sure it will come as no surprise to you that the purpose of the new medical legal fee schedule is to squeeze the profitability out of these evaluations for us as qualified medical evaluators. And I'm going to share with you some examples today as to how the parties are using the new medical legal fee schedule to squeeze the profit out of these evaluations. Now, from the perspective of the claims payers, they don't see it as squeezing the profit out. They see it as reducing the cost of these evaluations. So before we get into today's discussions, let's just briefly talk about where we've come from so far in this program. In sessions 1 through 5 of this program, we talked about some of the philosophy of the new medical legal fee schedule and what it was. What sequences of events led to the development of the need for a new medical legal fee schedule? And then we talked about the new billing codes under the new medical legal fee schedule, and we compared and contrasted the old codes with the new codes, and we dissected each of the codes to uncover the incentive, the operative incentive in the code, within the code, for both the claims payer on the one hand and the qualified medical evaluator on the other hand. And I shared with you several case examples as to how the new medical legal billing codes were to be implemented and could be used in the case of a new comprehensive face-to-face evaluation, a follow-up re-evaluation, and number 3, how the new codes are to be used for the supplemental evaluation. And I gave you a couple of different examples of each of those so that you could see how these codes are or were to be employed. And then in part 5, as we started to approach the April 1st, 2021 implementation date of the new medical legal fee schedule, we started to be able to see how indeed the new medical legal fee schedule was going to change the day-to-day operations of us as qualified medical evaluators. And as we started to prepare for evaluations after April 1st, we could start to see that, hey, the whole process of evaluating injured workers had to change and was going to change. And I shared with you in part 5 some of those new insights. Well, then we passed over the April 1st, 2021 implementation date, and we started using and living and experiencing the new medical legal fee schedule in our evaluations. And I shared with you how how you could effectively use the new medical legal fee schedule so that you could practice profitably as a qualified medical evaluator in an era and under a new system wherein the parties had the opposite incentive, which is to reduce the amount of expenses paid for medical legal evaluations. And I shared with you some secrets of success that you could employ in each and every one of your face-to-face evaluations with the injured worker, and then also secrets that you could employ in the preparation of your final report so that you could condense and compress time and get these evaluations done in the shortest amount of time possible, which is critical for you to succeed under a new flat rate fee reimbursement schedule. Then we talked about incentives in operation as we began to explore how each of the parties were leveraging the new medical legal fee schedule to their own advantage. And it started to become apparent that the new medical legal fee schedule strongly favors the claims payer, because the claims payer has control over the variables that contribute to the costs of the medical legal evaluation, specifically the main variable being the absolute page count of medical records being provided to us as qualified medical evaluators. It's the parties that were starting to wrestle control over the page count of records so as to be able to reduce the page count being sent to the qualified medical evaluator, thereby driving each and every evaluation closer and closer and closer to the established fixed rate fee provided for that particular billing code. So for the initial comprehensive evaluation, the code, the ML201 code, provides for $2,015, and the parties are starting to demonstrate that their overriding goal is to drive the cost of each and every evaluation closer, 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 and closer to that $2,015 flat rate fee. And the same philosophy applies for supplemental evaluations, and the same philosophy applies to re-evaluations. So I shared those incentives with you, and today, what I want to talk to you about today are some even further developments that we're starting to see that further continue to erode the profitability of these evaluations as the parties chip away, not only at the variable costs associated with the evaluations, but also with the evaluations themselves. And what we're starting to see is that the parties are starting to look around, behind, over, and or beyond the qualified medical evaluation in the resolution of the claim, thereby further reducing medical legal expenses. So it doesn't take a genius to determine that if the parties can avoid the need for a qualified medical evaluation with you, not only will they not have to deal with the costs associated with the page count of medical records, okay, they won't have to deal with the flat rate fee billing even in the first place. So the new medical legal fee schedule has ushered in a completely new game, which is impacting each of us as qualified medical evaluators. And I want to share with you in today's session how you can recognize these new incentives in operation and how you can respond accordingly to remain profitable in this work that we do. Okay, so I have a fascinating discussion for you today. In session number 10, our final session of our ongoing series related to the new medical legal fee schedule. Okay, so let's begin our discussion of the next chapter of what we're now understanding to be our new secrets of success under the new medical legal fee schedule. Now, the overriding philosophy for you to take to heart and to embrace fully if you're going to succeed and remain profitable under the new medical legal fee schedule is that in all things, in all procedures from start to finish of your evaluation, from the initial phone call all the way to dropping your report in the mail, time is of the essence. Let me say that again. Time is of the essence. And this is new because under the old medical legal fee schedule, we had time-based billing codes. We could bill for our time, and so therefore we had all the time in the world to take whatever time was necessary to do our procedures, to do our face-to-face evaluation, to write our reports. We had all the time in the world, and life was a dream sweetheart. But now, under the new medical legal fee schedule, we have fixed flat rate billing fees, reimbursement fees, that are not based upon time. So in all things, time is of the essence, because the more time you spend, the more time you squander, the more time you waste, the lower is your hourly rate of reimbursement under the new flat rate fee billing schedule. And the Division of Workers' Compensation expects us to be paid approximately $325 per hour for our time. Well, you can see very quickly that if you exceed the time that's allocated for each of the evaluation types, whether it be a comprehensive evaluation, a follow-up evaluation, or a supplemental evaluation, if you exceed the allocated time, the predicted time, your hourly rate can quickly drop into nothingness. And so time is of the essence. And so I shared with you several ideas as to how to maximize your time efficiency by changing your intake procedures, by understanding the importance of the medical records, by learning how to answer the specific questions presented to you in the cover letters from the parties. And then finally, by eliminating second cycles of action. And we're going to talk a little bit more about each of these in today's discussion, and I'll give you some new ideas related to at least a couple of these. Now, with regards to changing your intake procedures, it's important for you to understand that when you get a phone call for an appointment, a request for a QME appointment with you, those requests rank on a hierarchy of from low quality requests, meaning an appointment that has low likelihood, low potential to actually become a kept, reimbursable, compensable appointment for you. Those are low quality appointments, to the other end of the spectrum, which are high quality appointments, which are good appointments. Those are appointments that are expected to keep. They're expected to be reimbursed for that appointment, and you're expected to be reimbursed timely with no problems and no complications. So requests come to us on a spectrum of quality of requests, and your job is to determine what is the quality of the request that you're getting. And there are some things that you can do to drive low quality appointments up to high quality appointments, and there are some things that you cannot do. And so you need to understand that not all appointments keep. Even high quality appointments only keep at a rate of about 60, 65, 70%, and that percentage rate is diminishing. So certainly if you identify your request as a low quality request, that could be a request that you don't schedule. You don't schedule if the parties are not able to provide you the necessary documentation to demonstrate that request to be a high quality request. That can be a request that you just fail to schedule because it has no potential to keep as an appointment in the first place. So it's necessary that you change your intake procedures to only schedule appointments that are high quality appointments, and I'll share some more ideas as to why this is now even more necessary than ever before. Because imagine this, if you take the time, effort, energy, and the staff resources to schedule a low quality appointment, and that appointment does not keep, all of that time, effort, energy, and staff resources for which you have to pay actual hard costs is a complete waste. Okay, and this is happening with greater and greater frequency, and I'll share with you why. So it's more important now than ever that you only schedule appointments that are high quality appointments, And even for those high quality appointments, you need to understand that even not all of those appointments are going to be kept appointments. Okay, so this is absolutely critical. We talked about the importance of the medical records, and the medical records are taking on a life of their own and a character of their own and strategies of their own. And I'll share with you where the industry is going with medical records. In fact, there's a great debate across the industry now as to what medical records should be provided to the Qualified Medical Evaluator. And the applicant attorneys are arguing that every single record needs to be provided to the Qualified Medical Evaluator. Every single record. Whereas the claims payers and defense attorneys are arguing that not every single record is relevant to the issues that are in dispute with the particular evaluation. And so there's this clash going on right now that is still playing itself out between those parties. And here we are as the Qualified Medical Evaluator in between, having to handle and having to review whatever records are sent to us by the parties. But I can tell you that this is one of the great wars that's taking place right now, with the claims payers hoping to reduce the volume of records being sent to us to review, whereas applicant attorneys insisting that we need to have the opportunity to review every single document. And it's up to us, not up to someone else. It's up to the Qualified Medical Evaluator to determine which records are relevant and which records are not relevant, and that determination can only be made by the Qualified Medical Evaluator. And so this is an area of great debate currently and will be ongoing. And I'll share with you a little bit more about this in just a few moments. Number 3, we talked about how to redistribute time in your evaluation process such that you subtract time that you used to devote on certain sections of your report and devote and dedicate that time to more important sections of the report now under the new medical legal fee schedule. And now, more than ever, the sections of your report that are most important, that are most relevant, that are most useful to the parties who use your report, who read your report, and who use your report to resolve disputed issues, are those sections of your report wherein you answer the questions in the cover letters that are sent to you. So I'll just remind you that the purpose of a qualified medical evaluation is for you as the Qualified Medical Evaluator to provide answers to questions that the parties will have in the resolution of a disputed issue. So these cases come to us with some dispute for which the dispute needs to be resolved. In order to resolve the dispute, there are certain questions that need to be answered. The questions that need to be answered are presented to us in the cover letters. The cover letters that the parties send to us contain questions to which the parties need answers. So in your reporting from here on forward, what I'm suggesting to you is that you take the questions from the cover letters that you receive, take all of those questions and import them into your report template. And in your report template, in the discussion sections of your report, you answer each one of those questions from each of the parties sequentially. Now this can take some time, correct? You can see that this could take some time, especially if you have 2 cover letters, maybe even 3 cover letters. There could be a lot of questions. So this could take some time. Well, where's the time for that going to come from? The time for that comes from redistributing the time that you would otherwise dedicate in other parts of your face-to-face evaluation and other parts of your report writing process. That time can only come from other parts of your evaluation that are not so critical, like your physical examination. It's not necessary for you to spend copious time describing your findings on physical examination when your time could be much better spent answering the questions that are posed to you in the cover letters, okay? And we've spoken about that before, and I think you get that concept that you need to redistribute the times around so that you focus more time on this most important aspect of the evaluation, and you get that time by stealing it or borrowing it from other sections of your evaluation that are not so critical. And then we talked about eliminating second cycles of action, and we're going to talk more about that today as well. And what this means is that every time that you have to go through a process, a procedure, a cycle, a sequence of events, an action, every single time you have to duplicate that procedure, repeat that procedure, do that procedure over. It costs you money and subtracts from the time that's allocated for the entire evaluation, which is now a fixed and finite time. So each second cycle of action is a duplication of time, effort, energy, and actually it's a duplication of the cost associated with the first cycle of action. So in every process, you must strive to eliminate second cycles of action. Every time there's a second cycle of action, it's costing you money and it's chipping away at the profitability of your evaluation. And I have some ideas to share with you, even more ideas to share with you today, as to how you can eliminate second cycles of action. But before we get into that, let's focus in with a microscope on the importance of the medical records and talk about how the parties are using the medical records to actually eliminate the need, if you can believe this or not, eliminate the need for the evaluation in the first place. And this is going to be a mind blower for you. Okay, so let's talk about a couple more of these concepts, and we're going to start putting some ideas together as to how you can succeed and remain profitable under the new medical legal fee schedule. And what I want to talk to you about now has to do with combining the topics of changing your intake procedures to schedule only the high quality appointments by understanding the relevance or the importance of that, by understanding how the medical records are changing the entire landscape of the medical legal evaluation. So let's begin by talking about the importance of the medical records, and this is from the perspective of the claims payer. So it's now known, now that we're looking at medical records being reviewed on a cost per page basis, it's now known that it's the subpoenaed medical records, not the claims medical records, okay, it's the subpoenaed medical records, are the major cost driver of the review of records. Now, the reason for this is typically the claims medical records are limited. Those are a small stack because those medical records are only dated from the date of injury forward. Well, subpoenaed medical records can go all the way back to decades preceding the date of injury. And all of you are familiar with getting those stacks of medical records like from Kaiser or from Concentra, where one date of service can occupy as many as 6, 8, or 10 pages. And the page count can tremendously escalate very, very quickly with these subpoenaed medical records. So the philosophy and the procedures that the parties are now taking is going to blow you away. It's going to blow you away, and you're going to understand why it's more important than ever that you have your show, your ship, together as tight as possible, and your time increments boiled down to the minimum time increment necessary with no second cycles of action. Otherwise, you simply will not be able to do these evaluations for very long because you'll find the margins to be exceedingly slim and unattractive. So this is the procedure. This is the established procedure. This is the documented procedure, okay, documented, that the claims payers are going through in order to reduce the costs associated with not only the review of records, but also the medical legal evaluation itself. So number one, In order to reduce costs, the parties are going through a thorough review of the medical file as soon as the exam is set to determine how to reduce volume of documents to be sent to the QME. Now, there's a couple of important principles operative in this procedure. Number one, that this procedure begins as soon as the exam is set. As soon as the exam is set, the parties will then undertake a thorough review of the file once the appointment with you is set. So let's back out from this for just a minute. When the appointment is set with you is because you set the appointment. You took the phone call. You obtained the panel. You obtained the demographics. You dedicated a staff member's time and resources to setting up this appointment, to notifying the parties, to putting out letters and notifications in the mail. You dedicated resources at your own cost and your own dime to set the appointment. Once you did this, this sets in motion this sequence of events. So it's important that in knowing that once you set the appointment, once you pay the cost of the appointment setting, then the parties begin the procedure of trying to figure out how to further reduce their expenses and reduce their reimbursements to you by reducing the volume of medical records sent to you. This is going to blow you away. But this is the game that we're in, and you need to understand that this is how it's unfolding and that there's nothing that you can do about it. So therefore, it's more important than ever that you do control and exercise some control over the areas where you can have some control, okay? So it begins when the appointment with you is set. Well, once the appointment is set, then the next procedure is for the parties to evaluate the claim for early resolution. What is an early resolution? An early resolution is a resolution of the claim before the evaluation with you. Before the evaluation with you. If the parties can resolve the case before the evaluation with you, then there is no concern for the page count of medical records, and further, there is no concern for the cost of the medical legal evaluation in the first place. Thus, it's important that you take in only high-quality appointments, even knowing even the high-quality appointments are going to be evaluated for an early resolution, in which case, if the case does have an early resolution, the whole exam setting procedure by you will have been at your cost and will have been an exercise in futility for an appointment that never intended to keep in the first place, that intended only to be resolved early before your evaluation. Now, what the claims payers are trying to do as a procedure is they're trying to settle the case before the medical legal evaluation with you, and they're even offering more to the tune of $5,000 and $10,000 to avoid the increase for the QME records review, and further to avoid the cost of the medical legal evaluation itself. So is this valuable information to know? Is it important for you to know that once you set the appointment and your cost, that the parties are then beginning a sequence of events to try to figure out how to avoid the evaluation with you at all? In fact, they're preferring to pay up to $10,000 more to avoid the medical legal evaluation altogether. Now, does this make sense? It makes perfect sense, because the medical legal evaluation with you is a wild card. It's a wild card over which neither of the parties have any control. And the opinions and conclusions that you offer in your report could throw a major curveball for one or the other of the parties and could tremendously impact their costs and their profits, correct? So why not avoid the wild card altogether by offering even as much as $10,000 more to motivate an early resolution of that claim, and thereby sidestep the medical legal evaluation entirely? Now, in those circumstances, where the case cannot be resolved even with a juicy, compelling offer, the parties are sending only the medical records that are relevant to the medical legal issue to be determined. In other words, the parties are going through the subpoena medical records and are redacting the medical records and are pulling out of the subpoena medical records those records that they determine to be not relevant to the medical issue to be resolved. And guess what? Guess what? The parties are going to be successful in pulling out of the subpoenaed medical records sufficient irrelevant medical records to keep the total page count of medical records to below 200 pages, and that's what's happening, and that's what we're seeing as each and every evaluation comes closer and closer and closer to the flat rate fee established for the particular billing code associated with the evaluation. Okay, so let me just reiterate that. So while you're setting up the appointment, while you're taking the staff resources and the time to set up the appointment and the costs associated with setting up that appointment, the parties are simultaneously, once you have that appointment for them, they're simultaneously figuring out ways to avoid the evaluation with you completely. Now, if the parties are able to arrive at an early resolution of the claim, even by offering more than the cost of your medical legal evaluation, what does that mean for the appointment that you set? That means that you paid the cost of the early resolution. You paid the price that it took for the parties to begin the settlement proceedings. You financed it. That cost comes out of your operating capital because it will not come out of the cost of the evaluation. That comes out of your bottom line, okay? And that's not the only instance where you're going to suffer costs and losses. Now, many of these are not under our control. It's simply the cost of doing business in the medical legal business that we're involved in. So, therefore, the point I'm making is that the areas where you can control, time is of the essence, and you must constantly strive to reduce your time in order to offset the losses and the costs for which you have no control, okay? And I'll share with you a couple more examples to further impress upon you this point. So I want to talk to you about some recent costs that we've suffered over which we have no control. Number one, we recently had a reduction where the interpreter fee was not paid. We had an interpreter was ordered, we billed the appropriate code, the ML201-93, and I'm pretty sure you won't be able to see that right there, but I have it circled. ML201-93, the appropriate modifier for an interpreter. And the explanation of benefits came back for full payment for the ML201 portion of the evaluation, but there was a bill review reduction of $201.50, the exact fee associated with the interpreter. The 10% additional add-on for the interpreter was reduced. It was reduced. The final allowance here is $2,015 with a $201 reduction for no interpreter. Now, in order to capture the rightful charge for the interpreter, what's going to be involved here? There's going to be a second cycle of action involved here, right? My staff has already gone through the second cycle of action of calling the claims administrator to explain the problem, which took, of course, 3 phone calls. Resubmitting the entire report and the entire billing to the claims administrator, and now waiting an additional 30, 45 days for the additional $201. So this second cycle of action and this extra time increment, you can see, just chips away at the profitability of the evaluation over which we have no control. Thus, it's extremely essential that the areas where you do have control, you recapture these losses through minimizing your time. And in the end, it will all work out for you. You will still be able to maintain your hourly rate, but you have to factor in these losses when you look at all of your future evaluations, and you need to comport your future evaluations to offset these losses. I'll give you another example. Recently, we did our normal confirmation call 3 days prior to the face-to-face evaluation with the injured worker. 3 days prior with the injured worker, and the injured worker herself informed us that the case had settled and that therefore the evaluation with us was unnecessary. Neither of the parties, neither the applicant attorney, the defense attorney, or the claims administrator in any way gave us any notification that the case was settling or had settled. They simply, in doing their own business on their own through their own daily affairs, allowed us to continue to progress and prepare for an evaluation that was never going to keep in the first place. So who paid the cost of setting up the appointment? Who paid the cost of the administrative time in preparing this evaluation? Who paid the cost in preparing for the evaluation and preparing the template and determining what procedures needed to be done? Who paid that cost? We paid that cost. We paid that cost. Where's that cost going to come from? It can only come from future evaluations. It has to be offset by the profits from future evaluations. This is something over which you have no control. Therefore, the areas under which you do have control, it's essential that you exercise iron-fisted control in order to recapture these losses. Finally, I'll give you another example. We have an evaluation. We had an evaluation where we had failed confirmation calls. We started to confirm the examinee 7 days out. There was no response. 6 days out, we called again. There was no response. 5 days out, we called again. There was no response. Now we start to call the applicant attorney and ask them to please inquire as to whether their client is going to show for the face-to-face evaluation. No response. 4 days out, no response. Phone calls again to 2 parties. No response. Then we went through a weekend here, and then the day before the evaluation, again we attempted to contact the examinee. We contacted the applicant attorney. We got a response from the applicant attorney that said that they were unable to contact their client, and therefore they could not confirm that the applicant was going to attend the appointment. So where does that leave me as the qualified medical evaluator? Where would that leave you? That left me with the obligation to travel to the satellite office location to see if or if not the examinee was going to show or not, travel over an hour each way for an examinee who never did show. So I waited for this examinee from 9 a.m. to 9:30 a.m. First I traveled to the satellite office location, waited from 9 to 9:30 a.m., traveled back another hour to my office, for which I was able to bill a missed appointment fee, which doesn't cover the costs, including the fact that I had to pay a rental fee for the satellite office location, does not cover the costs, the lost opportunity costs of that missed appointment. And this is the type of thing that happens under which you have no control. Therefore, the procedures under which you do have control, it's essential that you exercise superior and supreme control. And I want to have some ideas I'll share with you now. Okay, so what can you do? Now that you know that while you're setting up the appointment at your cost and using your resources to establish the appointment, the parties are simultaneously behind the scenes are working to eliminate your appointment altogether. If that's true, what can you do? What are some steps that you can take to maximize your profit in this low margin, challenging environment? Well, let me share with you some ideas, and I wish you were here we would consider this to be a mastermind session, just as the insurance companies and the cost payers have their own mastermind sessions, to which I have some of their notes here as to how they plan on taking costs out of the medical legal evaluation. I want to share with you some ideas as to how you can survive and remain profitable and even continue doing this type of work as a qualified medical evaluator. So again, time is of the essence. So what I'm going to suggest to you, that you do not begin to work on the evaluation before 6 days prior to the face-to-face evaluation. Now remember, the ML200 missed appointment billing code allows us to bill for an appointment that cancels within 6 days. So do not begin work on the appointment, on any aspect of the appointment, before the 6th day, because if the appointment cancels 7 days out, any time and resource that you've devoted to preparation for that evaluation would be lost time. Now, this is different under this new fee schedule than it used to be under the old medical legal fee schedule. Under the old medical legal fee schedule, I used to preach that the face-to-face evaluation begins 3 weeks prior to the actual face-to-face evaluation, and that your preparation time began much before the actual appointment date. Okay, but that's all changed under the new medical legal fee schedule, wherein these cases are attempting to settle the moment we set the day, date, and time of the evaluation. So your first confirmation call, your first work of any type on the evaluation should begin no sooner than 6 days before the face-to-face evaluation. And I can show you in my storage locker here a stack of files this tall where we began work on the evaluation much earlier than 6 days prior to the face-to-face evaluation, that simply represents lost work, lost time, lost effort, lost energy, and lost resources, lost money, because we began work early on a case that never had any intention of making it to the face-to-face evaluation to begin with. So your first confirmation call should begin no sooner than 6 days before the scheduled appointment date. Then you begin the preparation on the reporting, on the evaluation. You begin your preparation, prepping your template, prepping your body parts, doing all your other confirmations with the satellite office, with the interpreter, etc. Only after the examinee confirms the appointment. Begin no work until you have a confirmation from the examinee, because there's as much likelihood that the examinee is not coming to the appointment as the examinee is coming to the appointment. So begin no work until you have a solid in-person confirmation from the examinee that the examinee plans to attend the appointment. If the examinee confirms the appointment, then you can comfortably and confidently begin your preparation, knowing that this is an appointment that's going to keep. This is one of those exceptions where the parties were unable to resolve the case, even with a high dollar settlement offer. They're unable to resolve the case, and the case is coming to you for the resolution. Now, you can be certain that if the case finally does come to you, in other words, it's one of those cases that does not resolve, you can be assured that it's probably a very complex case. It's a complex case with complex issues that the parties were unable to arrive at an agreement upon, for which they need your determination. So it's going to be a complex case. Thus, time is of the essence. In other words, you're only going to be getting evaluations that involve difficult determinations. The parties are going to be getting difficult determinations from you for a very, very low fee and for a very reduced amount of pages of medical records. Therefore, you must be very, very good and very, very quick at what it is that you're doing. Okay? So there's a couple of ideas about sequences of events before the face-to-face evaluation. What about the overall administration of your claim or your evaluation in general? Let's talk a little bit about some of those ideas now. Okay, and then finally, what are some other things you can do? What are some other actions you can take? What are some other mindsets you can adopt that will help you enhance the profitability of your medical legal practice in general and in overall, knowing that many evaluations for which you schedule appointments are not going to keep, because behind the scenes the parties are attempting to keep that appointment from making it to the face-to-face evaluation. Well, let me share with you some more ideas about how to conserve time in all aspects of your evaluation and to steal time and to capture time so that you can maximize your hourly rate. And what I want to talk to you now has to do with second cycles of action. Second cycles of action. In all efforts, we should strive to eliminate second cycles of action. Now, in order to illustrate this principle, let me tell you a story. Many years ago, in the early stages of my career as a chiropractor, I remember one patient who used to come into me for chiropractic treatment. And on almost every visit, either the same day or the next day, this same patient, after receiving a brilliant treatment from me, a perfect chiropractic treatment, an excellent chiropractic treatment that was rendered expertly and accomplished the objective for which the original intention was intended. Okay? In other words, she received a good treatment. This patient would come back either the same day or the next day and ask me to recheck it. And she would say something like, could you recheck that adjustment that you did? She said, I'm not asking for a treatment. I'm just asking you for you to check and see if it's still in place, because something doesn't feel right back there. She wasn't asking for a treatment. And so this patient would then get down on the table, and I would go through the process of checking to confirm that indeed the treatment that I had rendered was still in place, was still holding, was still effective, and that there was no additional treatment required. So in essence, this patient got 2 treatment cycles, two sessions on the treatment table for one fee. So her fee per visit was cut in half, and my time per visit was doubled. I find myself thinking, I'm glad I don't have 2 patients like this one, or I'd quickly be out of business, because she always required a second cycle of action. And second cycles of action in your medical legal practice will do the same thing to you. They will reduce your profitability and will cost you increased time, and it will be a double whammy right to your forehead if you have to employ or engage in second cycles of action. So let me give you some examples. A second cycle of action is any action that requires a duplication of time, of effort, and certainly of expense, such as what? Well, how about scheduling appointments? Anytime you take in a new appointment and there is information missing from the demographics for which you need to go seeking and calling and emailing for that additional information, is requiring a second cycle of action from you, which is reducing the profitability of that evaluation. Another example, how about missed appointments? Oh my God, talk about a major blow to the solar plexus. Missed appointments cause unnecessary travel time that wasn't even necessary. Time to and from the appointment was not even necessary. Lost time, lost opportunity for which you could have been in your office doing other things, could have been in your private life doing other things. There's lost opportunity cost, and there is actual hard cost. There's actual hard costs if you have to travel somewhere. There's actual gas costs, toll costs, rental costs at a satellite office location. Missed appointments are devastating, and they will never be adequately compensated for by the fee that's allowed for under the ML200. It just does not compensate for the lost opportunity costs. How about the situation where the examinee comes to the evaluation with their paperwork incomplete? Now, this causes unnecessary time and doctor costs, and I'll tell you that our procedure is to confirm with the examinee before the face-to-face evaluation that they've received their paperwork and that they will come to the evaluation with the paperwork already completed. Now, the responses to this question range from the response that they never received the paperwork, despite the fact that you have an accurate address for them. They never received it. You mailed it, but lo and behold, the United States Postal Service botched the job and the examinee never received the paperwork. Okay, so what are you going to do? Are you going to take the time to then email them the paperwork, for which they may not have a printer? They may not be able to print that out and bring it to the evaluation. Let's say they can print it out and they state that they will bring it to the evaluation completed. Do you think 100% of examinees actually come to the evaluation with the paperwork completed? Or do you think that there's a percentage that will come to the evaluation thinking that they will complete the paperwork at the evaluation? Okay? How about those examinees who state that they cannot complete the paperwork because they need the help from the interpreter to do the paperwork, and they come to the evaluation with the paperwork incomplete? How should you handle that? Well, what I'm suggesting to you is that you take a look at the paperwork that you sent to the examinee and make an assessment as to how necessary that paperwork is in the first place. How necessary is that paperwork in assisting you at arriving at opinions and conclusions quickly and accurately? Is it necessary? If it's not necessary, maybe you don't need that paperwork, because chances are very, very few examinees come to the evaluation with the paperwork already completed, ready to go on the appointed time. If the examinee's paperwork is not completed and the filling out of the paperwork starts to bleed into the appointment time, then you're suffering from a loss of profitability of that evaluation. And I would suggest to you that perhaps that paperwork is not as necessary as you once thought it should, could, or ought to be. Okay? And then finally, or not finally, I have two more examples. Duplicate billings. I just shared with you an example of a duplicate billing that causes unnecessary staff time, unnecessary staff cost, a delay in the recovery of money that was due to you earlier without extra staff time, without extra staff costs. In other words, duplicate billings are extremely, extremely expensive, and you should do whatever you can to guard against the necessity of having to submit billing on multiple occasions. Now, finally, I'm going to give you an idea regarding deposition scheduling, because I found that with scheduling depositions, the parties can go back and forth unnecessarily and at great length to arrive at a mutually agreed upon date and time for the deposition. And as an example, I have here an email string, 5 pages. This is a 5-page email string wherein we attempted to finally arrive at an agreed upon deposition date and time. And it began by the parties one of the parties getting in touch with us and advising us that they wanted to have a deposition. Could I please provide them with 3 dates that I would be available for deposition? And she would get back to me with a selection of one of those dates. Okay, so you're familiar with this drill, right? This is how it goes. Well, I provided 3 dates, and the party got back to me and said, those dates all work for us, but they don't work for the other party. Can we have 3 additional dates? So in a second cycle of action, I then took out my calendar again, looked at my calendar, and provided 3 alternate dates for the parties to consider. Well, I got a reply, so that was a second cycle of action. I got a reply from the legal secretary, and she selected one of the dates. All fine and good. So we put it on our calendar. She wrote us back, and she said, actually, that date I just realized this is several days later, I realized we had a hearing on that date. Can you provide us with 3 more dates so that we can consider 3 new dates? And then a 3rd cycle of action, and on it went again, at least into the 4th cycle of action. And I thought to myself, this is too much. It's too much time devoted to an unnecessary procedure. So what I'm suggesting to you is that you approach deposition scheduling a little bit differently to bring it down to fewer cycles of action. So for example, when you get a request from the party for a deposition date, and time, how about if you give the party the opportunity for the party to look at the party schedule. Okay, this is the party then needs to do this cycle of action themselves, to look at the party schedule and to confer with the other party to agree upon a mutually agreed upon date, and time, and for them to notify you back as to that date, and time, and then you accommodate that date, and time. Now you can bracket this so that it doesn't run wild. You can bracket this by saying, I'm available any Monday, Wednesday, and Friday after such and such a date, and give such and such a date 6, 8, 10 weeks into the future. We're required to schedule these within 120 days. So why don't you go out 8 weeks into the future when your schedule is more clear and advise them that they can pick any Monday, Wednesday, Friday at 9 a.m. by Zoom. Just let you know what day they agree upon, and you'll put it on your calendar, and let the parties go through the 2nd, 3rd, 4th, 5th, 5th, 6th cycle of action, and you reduce the number of cycles of action that you engage in. So, doctors, I hope these ideas help you. These are just a handful of ideas. This is not a complete list of action steps that you can take to increase the profitability of your evaluations moving forward. But this is some philosophy for you to consider in moving forward. And that is, the overriding philosophy is that time is of the essence. You know, as we speak, the parties are conferring together to figure out ways to reduce costs for medical legal evaluations, and they're not covert about it. Well, this forum between you and I on these blogs, this is one of the only opportunities that we have to mastermind and to share ideas as to how we can best succeed in this medical legal evaluation business ourselves. So I'm sharing these ideas with you that I've collected from my consulting clients and from other qualified medical evaluators that I have the opportunity to speak with, and I'm bringing them to you in the spirit that we as qualified medical evaluators can succeed in this business. We just have to get better and better and better and quicker at what it is that we do, and I've shared several ideas with you in this series of programs. So this concludes our discussion of the new medical legal fee schedule. As I said earlier, this is our 10th session. So I'll come back to you probably in 10 to 12 months from now, and we'll have a new discussion regarding the medical legal fee schedule. But for today, I wanted to share these ideas with you so that you can continue to profit and succeed as a qualified medical evaluator. So for today, this is Dr. Perry Carpenter. I want to thank you for taking the time to join me on this discussion. I look forward to being with you on future discussions as well. And for now, I'm wishing you best success in your career as a qualified medical evaluator.